All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Darrell Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I object to that, Your Honor. I do not identify by that name and would like the opportunity to state that I am here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr. Brooks, it wasn't the proper time to do that. That's now the third interruption. So,
with all due respect, Your Honor,
by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done. I have a number of documents that I need to discuss this morning. Mr. Brooks, you do not have a right to interrupt the court. And every day, Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware that's another interruption. I'm well aware. Stop talking.
Which I have the right to do.
I'm well aware, Mr. Brooks, that you object to the name that has identified on the information and all documents in this case. Your objection is noted. It does not need to be. You are unable or unwilling to abide by simple rules of civility. You interrupt. You don't wait for anyone to finish. And it will result with you being removed from the courtroom. So you are once again reminded of that. I'm going to give a little slack at the moment only because we are not in the presence of the jury. Yet again.
You just weren't speaking,
all right,
so
Mr. Brooks, you are now going to be removed to the other courtroom.
I don't consent to that.
I have had a dozen or more interruptions. You'll be off the record while we do that. Thank you, everyone.
I don't agree to a stop. I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I have a right to be present for trial.
Jury comes in. On or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Wilhelm Haspel with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous weapon, contrary to section 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The defendant has entered a plea of not guilty to each one of these charges, which means the state must prove every element of each offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. That tactic by you.
So
The fact that you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations. So at this point, Mr. Brooks,
I respectfully object
stop
to that.
interrupting me, please.
I merely
Stop
just seek
interrupting
to
me,
understand.
sir.
I'm not. I was
If
in the
you
middle
have
of
an
saying
objection,
something.
write it down.
I thought that applied to me being.
It's
from
applying right
another-
now since you keep interrupting me while
So
I'm talking.
so what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is there
All right,
a reason
I'm not giving you advice. I'm not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction,
That's inaccurate.
but I have addressed them.
That's inaccurate,
All right,
Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. Some of your filings do not require a specific line-by-line response by the court. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be. But we are continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case.
Your
Madam
Honor.
Clerk, have the jurors brought
Your
in,
Honor,
please.
What you're doing is judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, that I'm not allowed to question Your Honor, which is my right. I've merely brought up subject matter jurisdiction because it has merit. I've merely tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings, and I should be able to understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the waiver back in the way that I felt that it should be altered, and you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you. That should have let you know right there further that I did not understand the proceedings, and that was some of the issues that I'm bringing up now. It's merely just clarification, Your Honor. I don't understand what is going on. It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the proceedings.
Do you
It is
understand when I tell you not to interrupt me?
No,
Do you
no, I do not.
understand when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
I still would like to ask
Mr.
questions,
Brooks?
Your Honor.
Stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect,
Mr. Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity
I disagree.
later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Mr.
that-
Brooks,
You have
The
not
jury
shown-
is in the courtroom.
I understand that,
You
Your Honor.
continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It's my right.
Mr.
I'm
Brooks,
merely
you
exercising
can
my
stand,
right.
you need to be quiet. Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks, please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking to understand, Your Honor.
Mr. Brooks, final warning.
I'm seeking to understand, Your Honor. It must be some clarification.
Mr. Brooks, I want you here.
I want to
Stop interrupting me.
be here. You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, cannot.
Ladies and gentlemen of the
can-
jury,
you can
I'm going
move
to
me to the other
continue
thing.
with the jury instructions. This court is under no obligation and in fact cannot give him legal advice and is not required to explain court procedures or the law. He was provided with a couple of different copies of the jury instructions. There was an original set, and then there was the set with the modifications. All of the instruction numbers are left in the jury instructions. There was a discussion on the record yesterday about access to jury instructions, even though this court is under no obligation, and explained that to him during the colloquy regarding the waiver of counsel, that I could not make any assurances about access to legal materials. I note he has his objection sign up. His objection is noted. But at this point, I am still reading through these objections. I don't plan on having the parties make any additional comments regarding the jury, the preliminary jury instructions. Again, we had ample opportunity for that discussion prior to the court's approval.
The proposed sovereign citizen defense has, quote, no conceivable validity in American law. I think that's applicable to several of these filings here, Your Honor, and I think that's relevant authority throughout the remainder of this trial, that these sovereign citizen defenses have been attempted. There's a lot of cases on this. That's the most recent from the Seventh Circuit that I could find. In no way have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts, and there's significant case law on point, but that's the most recent and appears to fit really well with the facts of this case.
I would note the documents he refers to in this particular piece of paper references the notice of special appearance, the statement of particulars, both are by affidavit. Those are two of the common sovereign tactics. And I believe Benaby, and the language that you cited, is directly on point, and that is why I can simply deny the request to address those filings without any further discussion or hearing on them, even without giving Mr. Brooks an opportunity to further respond. He's holding up his objection sign. Mr. Brooks, you know, I frankly did that for your benefit. You raised what really is an important issue, and I appreciate that. I was a little surprised by it, but then when I heard you explain further, I thought, you know, he's got a point there. He had been removed for some of those proceedings. You may not have seen her. I'm not making a finding on that, and so that's why I backtracked a little bit, said I would look into it. So I'm not sure why you're objecting at this point. I took an important piece of information that you were relaying, and we had it, in this case, it was confirmed that the juror did not attend any proceedings, and so that will address your issue with her.
Correct.
Okay. And then just to the right of that, there's something marked as a mobile gas station, is that correct?
Yes.
Objection.
Overruled.
There's somebody that's running the parade as far as lining up the participants and making sure everybody that's walking in the parade is where they're supposed to be, correct?
Correct.
Is there a title for that person?
Boy, I wouldn't know.
Your objection is noted, it's overruled. He may testify about the question asked.
Or is there somebody that you were dealing with directly that was kind of responsible for the units of the parade and you're responsible for the security of the parade?
Yes, there was a.
Overruled, he may answer.
Can you estimate how many spectators were present?
Objection.
At what time?
I'm sorry, at the start of the parade. There's spectators on both sides of the road, north and south sides of Main Street,
Correct.
and all the way from Hartwell all the way down to Veterans Park at the end there near Wisconsin Avenue.
Yes, I'd say the majority of this.
Hold on, there's been an objection. Go ahead, what's your objection?
That is hearsay. We can't know sure where everybody was at.
The objection is noted. It is overruled based upon the foundation previously laid by the witness. Go ahead.
And you had mentioned the units were staging on White Rock near where you were posted, is that right?
Yes.
And did you see as the units would enter the parade route, then they all kind of move forward, I'm assuming?
Yes, the.
Hearsay.
Overruled.
Do you remember how you had your squad positioned?
Objection, that's hearsay.
Overruled.
I had my squad positioned across White Rock Avenue in an east-west fashion, essentially in the middle of the roadway. The road is much wider than the SUV squad I was driving is. I positioned it that way to give a visual representation to motorists that the road wasn't open.
And is your squad marked or unmarked?
It is unmarked.
Objection, irrelevant.
It's relevant. The answer may stand. Make sure if you hear an objection, sir, that you wait until I rule on it too. Thank you.
Are there red and blue lights on your squad car, sir?
Yes.
Objection, irrelevant.
Overruled. The answer may stand.
Did you have your red and blue lights activated as it was parked across the roadway?
Objection, irrelevant.
Overruled.
Yes.
You remember hearing something about a disturbance near the boat launch?
Yes.
Objection, hearsay.
Are you offering it for the...
Foundational, Your Honor.
All right, it's not being offered for the truth of the matter asserted. The objection is overruled. He may answer. I believe he answered yes, and it may stand.
All right. What do you remember hearing about an incident at the boat launch?
And I overheard actually on his police radio that he was wearing squads that were not assigned to the parade being sent to a fight at Frame Park that involved knives.
Were you aware of any vehicles being associated with that fight?
Objection, irrelevant.
Overruled. He may answer.
I did not hear of any vehicles associated.
What do you remember next, sir?
I knew when I saw a red SUV traveling toward me at a high rate of speed.
What do you mean by high rate of speed, sir?
Objection, that's hearsay.
Overruled. He may answer.
I believe the vehicle is traveling in excess of 40 miles per hour.
What's the posted speed limit there on White Rock Avenue?
It's a 25 mile per hour zone.
What about Main Street in downtown Waukesha? What's the posted speed limit there, sir?
The speed limit
Irrelevant.
Overruled. It's relevant.
the speed limit throughout the parade route is 25 miles per hour.
What did you do when you saw this red SUV traveling at a high rate of speed?
Objection, leading the witness.
The objection is noted. It's overruled.
What did you observe the path of travel for the SUV to be?
Objection, that's hearsay.
Mr. Brooks, it's not hearsay. Your objection is overruled. You may answer.
Could you state the question one more time?
Sure. Where did you see the SUV go? It's a better question.
Objection, irrelevant.
Overruled.
The SUV entered the parade route.
Did you notice the car slow down in any fashion?
No, in fact,
Hearsay.
It's not hearsay, it's overruled. He may answer.
What did you do?
Upon seeing that, I got on my radio in an attempt to notify other personnel assigned to the parade route. I stated that a red SUV had just blown by me.
Do you remember using those exact words, sir?
Objection, that's irrelevant.
Overruled. He may answer.
I don't know if I said a red or maroon SUV, but I remember saying that it had blown by me.
Were there parade units still on White Rock attempting to get onto the parade route at that point?
Yes.
Objection.
Were you able to see the vehicle clearly as it
Hold on,
went?
he
I'm sorry.
objected. It's overruled. Go ahead.
From where you were standing there, were you able to turn and watch the SUV as it traveled past you down White Rock towards Main Street?
Objection.
Overruled.
Just ask that.
Did you see that clip, sir?
Yes.
Is that a video clip you've seen before?
I have seen that, yes.
Okay. Do you believe that's a true and accurate representation of the SUV traveling on White Rock Avenue near the start of the parade at Main Street?
Yes.
Move for admission and permission to publish, Your Honor.
Any objection, Mr. Brooks?
Can you repeat that? I'm sorry.
The state just moved admission of Exhibit 2.
No, I object to that. Keep it.
All right, the objection's noted, it's overruled. Exhibit 2, ladies and gentlemen of the jury, is received. Permission to publish is granted.
Thank you. Did multiple officers respond
Yes.
from within Waukesha County?
From when,
Objection, irrelevant.
Overruled.
Waukesha County and far beyond.
Thank you, sir. I don't have any other questions at this time.
Mr. Brooks, do you have any questions for this witness?
Yes, I do. Good afternoon, officer. First off,
Good afternoon.
I'll say this is very emotional, so I'm gonna try my best not to keep you up there any longer than you would like to be. My first question is, I noticed that you are in uniform today. Is it fair to say that if you weren't here testifying that you would have been on duty today? Is it fair to ask that or say that?
Not have been at work today.
So did you feel the testimony that you would be given at trial today warranted you to be in uniform?
Objection, relevance, Your Honor.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
You said you've been in duty for 18 years, correct?
Yes.
In any of those 18 years, have you ever come across or had any interaction with the plaintiff in this matter?
Objection, vague.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
How long have you known the plaintiff?
Objection, vague and irrelevant.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
Do you see the plaintiff in court today?
Objection, vague and irrelevant.
Sustained. Next question.
Do you have any knowledge of the plaintiff?
Objection,
Sustained.
Have you ever even seen the plaintiff in this matter?
same objection.
Sustained.
I want to go to the clip that was just shown.
Would you like it shown to the witness again and published to the jury?
I'm sure would he prefer for it to be so again?
I just wanted to know if that's what you were asking. You can certainly question him about it, and if need be, it can be shown again.
Okay, can you show the witness the video clip again?
Sure. All right, I can tell from my monitor and the witness monitor it is up, but it's not being projected to the courtroom other than that. And you can go ahead and play it. All right, your question, sir.
In that clip, is it fair to say that you can see that there are people walking in the street and on the sidewalk? Would that be fair to say?
Yes, I could see that in the video clip.
Do you see anybody being targeted or being in a panic to get away from the vehicle?
No.
Do you see the said driver of that vehicle intentionally trying to hit anyone in that video?
No.
So again, I would ask, were you brought here today to testify on behalf of the plaintiff?
Objection, asked and answered.
Sustained. He already answered that he was why he's here.
Again, I would ask just one more time for the record. Do you see the plaintiff in court today?
Objection.
Sustained. Do you have any other questions, Mr. Brooks?
Do you know of the plaintiff at all whatsoever?
Objection.
Sustained.
No further questions.
All right, thank you.
About?
Yeah.
I move Exhibit 3 into evidence and ask to publish.
Any objection, Mr. Brooks?
Yeah, my objection would be, you've only played 5 seconds of the video, whereas the other 5, you just said 10 seconds that you would play. I'm curious to see the rest of the video.
Your objection is noted. It's overruled. This is for foundation to establish it's what the witness is going to testify about. She's testified. It's a fair and accurate depiction of the events that unfolded in her presence. And I will receive Exhibit 3. Permission to publish is granted.
Who's the person in the gray hooded sweatshirt?
That's Daryl.
The objection's overruled.
Okay. Did Mr. Brooks say anything to you or Erica or Nick as he was leaving?
He told Erica he was. Oh.
The basis for your objection, you said objection, right?
Is hearsay and irrelevant?
Is it being offered for the truth of the matter certain?
Well, it's a statement by a party opponent, so it's not hearsay.
Oh, it's his statement. Sorry, I think I misheard what she said. All right, the objection is overruled. If it's, she may testify as to words that you spoke on this occasion. Go ahead.
I move Exhibit 5 into evidence and ask to publish.
Any objection?
Yep, on the grounds of that is hearsay.
The objection's noted. It's overruled. Exhibit 5 is received. Permission to publish is granted. All right, Mr. Brooks, do you have any questions for this witness?
I sure do. So, my first question would be, you seem to be unclear about when you met Erica. Would you say it was roughly October or November because you wasn't sure which one?
Roughly in between.
Roughly in between.
Yeah. I know it was before Christmas.
Well, you just said that you had never seen her quote unquote boyfriend or whoever she was referring to as that before the Christmas parade. Is that correct?
That was, the Christmas parade was November, right?
He's asking you if you had seen.
Not before, but the Christmas parade was November. I'm just asking, right? Okay, so no.
Did she? Do you want her to restate her answer? She answered. She confirmed your question.
I wanted to be direct.
Okay, no, I have not.
So you just testified that you can identify who was driving the said vehicle as soon as you saw the video played. If you've never seen the driver before that day, how would you even know who it was?
I'll object. That is not a clear question. This is just going to confuse the witness. It's confused me.
Also state it, Mr. Brooks, rephrase the question, please.
Would you play the video again, the first 10 seconds? I'm guessing that it was.
It'd be Exhibit 3.
Exhibit 3. You want us to look? You want the first 10 seconds of exhibit played?
Show the witness the first couple of seconds of the.
All right, it's up.
Now you just said, you just testified.
Hold on, it's playing. You want it to stop now?
Stop.
Okay,
You
Play the
just
first 13 seconds for the witness.
thank you.
you just testified that as soon as you saw the vehicle come into the camera view, you said, "Oh, there's his car." How would you know whose car it was if you've never seen this person before that day?
Do you understand the question?
Yeah.
Go ahead and answer.
Because I was told that she was going to meet up with Daryl Brooks.
So you were told this directly from Erica.
Yes.
Did at any time she ever tell you what kind of car he had and what kind of car he would be meeting up with her with, quote unquote?
No.
So how can you identify that it was the said person's car if you had no knowledge of what vehicle this said person would be driving, or who the person even was, or what the person even looked like? How would you know?
Because I was told it was Daryl Brooks.
And so you were told that it was this name, but you were able to identify the vehicle and the person on the first day that you ever saw them.
Objection.
Is that-
Asked and answered.
Let him finish his question.
Again, as soon as the car came into camera view, you immediately said on the record just a few minutes ago, "Oh, there's his car." Who is him? Who is his? Who were you referring to?
Daryl Brooks.
And you would be able to know that that was quote unquote Daryl Brooks just by seeing the car come into the view of the camera?
I'll object based on an asked and answered question.
Sustained. Mr. Brooks, are you trying to ask her whether at the moment in time she first saw the SUV, did she know who was driving? That would be a relevant question.
Did you know who was driving the SUV that you saw when you saw it?
Not in court, but when you first saw it on that date.
Yes, because I don't see why Erica would be talking to anybody else and getting yelled at by somebody else.
But did you know at that moment who was driving the car?
Yes.
And how would you know that? You just said that you had no knowledge of the vehicle that whoever Erica was meeting up with would be driving. So how would you know that?
Objection, asked and answered, and argumentative.
Yeah. Her answer previously, Mr. Brooks, was she's basing that on what someone told her, not based on what she saw at that point. That's at least how I took it.
So Erica told you the vehicle and how the vehicle would look?
Do you understand the question?
Say that again.
Mr. Brooks?
Erica, I'm
restate
sorry,
the
Your Honor.
question. No, that's okay. Restate the question, sir.
So let's back up a little bit. Erica told you that she was meeting up with this Daryl Brooks, correct? That's what you said, right?
Correct.
And did she at any time tell you what vehicle this person would be driving and how the vehicle looked?
She did not.
So the first time you saw the vehicle, did you know who was driving the vehicle?
Yes, when she told me. When she told
What
me.
he's asking you, though, is did you know based on personal observation,
Oh,
not
no,
based
not
on what
personal
someone told you?
observation. Wait. So personal observation? Oh, no, never mind. Okay, yeah.
So let's just make sure the record's clear what your answer is.
It's based on what I was told when I met up with her.
So it was told.
That's been established. It's been established what was told. So next question.
No, I was going to a different question. I didn't get to it.
All right, well then ask it, please.
I'm trying to. So you were told after the vehicle drove away and you and Erica were alone? Is that when you were told?
Yes.
So it would be fair to say that before you were told this, after the vehicle drove away, you did not know who was driving the vehicle, correct? Would that be fair to say?
Oh, I had a suspicion it was Daryl.
You had a suspicion or did you know?
Had a suspicion until I
So
asked
you
her.
didn't know.
Objection, argumentative.
Yeah, so we've kind of been a little bit circular here. So the objection is sustained. I think we need to be clear, Mr. Brooks, when you ask your questions about what point in time. It's one thing to talk about when she first sees the vehicle because there's been no contact between her and the vehicle, but it's a different point in time when it's later. So you need to make clear at what point in time you're referring to so that your question is clear.
Got you. Identified the alleged defendant in court. Would that be fair to say?
Yes.
And the alleged defendant that you identified was the same person that you saw driving the vehicle that day.
Yes.
The video also shows that, well, let me back up. Matter of fact, let me ask a different question. You made reference to hanging out with Erica in a park, correct?
Yes.
With maybe one other person
Yeah.
present?
Yes.
Thank you.
Hanging out, what were you guys actually doing?
Drinking?
So, would it be fair to say that because of alcohol being involved, that there may have been a misinterpretation of what you saw? Or
No.
what you thought you saw?
Objection calls for speculation.
The question, the way it's asked, calls for speculation. If you could please rephrase it.
ask it different. How much were you drinking? Was it a few beers, a bottle,
Half a
something to
pint.
that effect? Half a pint. Do you remember what you were drinking?
Vodka.
Do you remember if Erica was drinking?
She was.
And you said that you separated at one point to go hang with another person. I can't remember the name, but would that be fair to say that you separated from Erica to go hang out with another person?
I did say that.
Was that person also drinking that day?
No.
Did that person overhear any conversation between you and Erica?
No.
Would that be the same person that was saw in the video?
Yes.
So that would be Nick. Is that fair to say?
Yes.
And is it true that you did give a statement about what you saw and heard that day? Would that be
Yes.
fair to say? Would it be fair to say that in this statement that you gave, you never mentioned the person that you saw driving make any threats? Would that be fair to say?
I never mentioned.
Well, I have the statement right here in front of me. Would it be fair to say that the statement that you gave that day, that you do not say in your statement that you heard any threats being made or yelled towards Erica? Would that be fair to say?
Possibly.
So do you remember giving a statement?
I remember giving a statement.
Do you remember what you said in your statement?
I do.
So I'm going to ask you again because I just asked. I have your statement in front of me. You did not mention any threats being yelled or made towards Erica. Would that be fair to say?
I did mention some.
What exactly did you mention?
That you were yelling at her, saying that you were gonna kill her and to get in the car.
And that's in your statement.
Yes.
Would you like me to read your statement to you?
Yes.
You sure?
Yeah, sure.
So I'll object based on the procedure that the defendant is employing at this point.
Sure. Mr. Brooks, there is a procedure. I can have the state bring up her statement, I hope, electronically to show her. It would,
That
and
would be
then,
fine, Your Honor. You
all right.
can bring it up for her to see.
I think there may have been some misunderstanding on the nature of this statement in question. This witness provided a statement to a police detective who then wrote a police report summarizing the statement. So the proper method at this point for the defendant would be to confront her by orally quoting from that, asking if she said or didn't say these things. To show her this statement we're not refreshing her recollection. She didn't write this.
I see. So I didn't know that, but that certainly makes a lot of sense. Mr. Brooks, did you hear what Attorney Wichelt just said about the procedure?
Is it a way to verify that that is, in fact, procedure? Just to be clear for the record. Can we verify it?
I had referenced earlier that I thought you were trying, we might be showing her the statement to help refresh her recollection, but I don't have any of the statements in front of me, and I wasn't aware that it's the police report that may be referenced as written by someone other than this witness. She wrote a statement apparently, but the police report is a summary of her statement. So at this point, I don't need to show it to her, but you can ask questions. We'll bring the jury back out and you can continue.
Would this be left up for me to see though? Wow.
We can leave it up.
We can leave it up.
Okay.
Is the part that's up sufficient, or do you need to scroll up? Does the state need to scroll up a little bit for you?
I would only need this part that's on my screen now,
Okay.
and then you whoever's strolling, stroll down a little bit past that to the second part. Up.
How about that? You should be able to see both parts now. Starts with in summary near the top,
Yeah.
and then that's page 2 of 5, and then down below, presumably it says 3 of 5, but
So, Miss, is it Runkle?
It is.
You stated earlier that when you were hanging out with Erica at the park that you were drinking, right?
I did.
And you also stated that you guys separated and you went to go hang out with someone else.
With Nick, yes.
With Nick. You did state that Nick wasn't drinking, right?
Yes.
So I want to ask, earlier when I asked, I think you were asked by Attorney Whitchild if you heard any yelling or anything being yelled at Erica, or I'll forget how you phrased the question, but did you hear any yelling or anything directed towards you guys? And do you remember what you said?
I heard that you were yelling at Erica, telling her to get in the car, and that you were gonna kill her. That was you were gonna kill her was after the fact that you headed out, but that's probably not what you're asking. The fact of you were yelling at her, telling her to get in the car, was the time when you were around. Oh, I mean, sorry, Brooks was around.
Brooks or you? You said you, and then you said
Brooks.
Brooks. But you did state that you had never seen Brooks before November 21st of 2021. Would that be
Right.
fair to say?
Right.
And you also did say that you had only heard of him through Erica, correct?
Right.
At any time, did you ever observe any phone conversations or interactions between Erica and Brooks?
Am I allowed to answer that?
He's just asking you whether you have, not the content of any of those.
I have.
Would it be fair to say that you knew a lot of details about their relationship? Would that be fair to say?
I did.
What specifically did you know before November 21st, 2021?
Mr. Brooks, I'm sure you want to ask that question. Think about some of the pretrial rulings I've made.
Let me rephrase that.
Okay, good idea.
I'm sorry, I'm new. So, in your statement that I'm looking at right here on the screen, it says, it is Runkle, right?
Yes.
I don't want to mispronounce your name. It says, Runkle further stated that she heard Brooks telling Erica he was going to smash her face in and that he was going to kill her.
Yes.
I didn't.
I'm sorry.
Is that what you heard?
Yes.
So you didn't hear what you just testified to hearing,
No.
or did you hear what I just read to you?
I heard that after you were leaving.
After
Not that what you just read. I heard that after you were leaving.
you do know that this is your statement that I'm reading from, right?
I do.
We've established that, and this is argumentative.
Sustained. Rephrase.
I'm trying to figure out which one did you hear.
Objection, vague.
Did you hear the I'm going to smash your face in, or did you hear what you previously said?
Well, I heard when you were sitting there arguing with her, I heard that.
Who is the you you're referring to?
Oh, I'm sorry. Brooks said that when he was arguing with Erica.
And you claim that it says right here, but through knowing Patterson, she did know that Brooks was Erica Patterson's boyfriend. Did she ever tell you that Brooks was her boyfriend?
She said you were, I'm sorry. She said Brooks was her ex.
I'm a little confused by the statement and then the testimony right now.
Objection, that's not a question.
Sustained. Mr. Brooks, you need to formulate a question for the witness.
Did you ever hear, now this is coming from your statement, Runkle stated that after a short dispute between her, Kirby, I guess that would be referring to Nick.
Yes.
After a short dispute between her, Kirby, and Brooks, she saw Brooks get back into the red SUV and heard him saying something to the effect of, I don't swear, so F you, effing bees, you're dead. Did you at any time hear anything like that?
Yes.
So when you just testified, why did that part of your statement never come up? Why did you never say that?
Because it probably wasn't brought up at that time, but it's in my memory.
So what all exactly did you hear?
I heard what you were
You
saying.
heard you say at this time? Like, the question's not
What
clear to me.
all-
Like, what time frame? Who are we talking about?
When, because in the video it's clear that
Hold on, go back to your question. I didn't mean for you to not ask it. I just want to make sure I understand specifically who you're asking this witness about statements that were made.
I'm asking about who she said was the individual driving the vehicle.
Well, that's different than what you just asked. So if
Well,
you want to change and
because
go to
you
that,
just
that's fine.
you just clarified it a little bit. So what exactly did you hear coming from the individual who was driving the vehicle?
I'm sorry, can we just clarify at what point we're talking about?
Exactly.
At the point that I guess I would refer back to the video at that point that we saw on the video.
So what point of the video? There's lots of points. It was many minutes long.
Roughly, I'm not sure, I think it was
Can you describe what part of the video you want?
the part
her
of
to
the
talk about?
video, when that she testified to, where she said she had the green gloves, and
So
she was
in the
standing.
beginning
She was
of the
standing
video?
no, it was like towards the middle. She was standing in the street, and she said she had the green gloves because I think somebody asked her which one was she,
Right.
and she
I
said
remember
the
that.
one with the green gloves.
I remember that.
At that point, did you observe anything being said out of said vehicle? Did you hear anything being yelled or screamed or anything like that at that point?
Well, before I showed up, I heard yelling.
You heard yelling before you showed up.
Yeah, because like before I showed up into the video.
So how far were you down the street that you were able to hear what was being said?
Objection.
Not.
Calls for a fact, not an evidence. She didn't say what she heard. She didn't say she could understand what was said.
She can answer the question. I'm going to overrule it. I understand what the state is saying, but I think he's trying to establish where she was at that point in time. So go ahead and answer.
No, okay. I was right where you pulled up the second time.
Are you sure you know what I was asking?
It was not entirely clear to maybe all of us, but I was trying to give you some leeway. So
I knew you understood where I was going with that. Were you at a, let me say it like this, were you at a distance before you came into that video? Like approximately how far away were you from the vehicle and from Erica before you heard anything being yelled or screamed, as you say?
I was at a distance.
So would it be fair to say that it would be hard to hear the conversation that was being had?
Not really. Brooks was yelling pretty loud.
So you were able to hear the gist of the conversation from the distance that you were at?
Yes.
Even with a parade going on and a street full of people, you were able to hear from a distance, which you just said you were at a distance, you were able to hear the gist of the conversation.
The parade was nowhere close.
answer the question. Were you able to hear?
Oh, yes, sorry.
You were able to hear, even testifying that you were drinking vodka.
Yes.
What else did you hear?
At what point and by whom?
At the same point, what did you hear from Erica at that point?
I don't remember.
But you remember hearing something from the driver of the vehicle who was inside of the car.
Yep.
But you don't remember what you heard from Erica, who was outside of the car and would be more easier to hear.
Okay. Thank you for being specific at that. I
You're
remember
welcome.
Erica sitting there telling me that she wanted to go.
So she was telling you that from you being at a distance.
No, she was right next to me. That was when she was walking towards. She said, "Come on, let's go."
At what point was that? Because you just testified that you were at a distance.
Objection, argumentative. I'm also going to object to the manner in which this defendant is asking this witness these questions. He's intentionally misleading her. He's trying to confuse her.
Mr. Brooks, the purpose of cross-examination is to ask questions that are relevant, test her credibility, other things like that. It gets to be a little confusing, at times maybe a little argumentative. I don't have all the reports in front of me, so I can't say whether it's misleading or not. But ask a direct question. You're able to ask leading questions so that she can answer directly. Be as specific as you can, time, place, circumstances. It's helpful for all.
I mean, the video is very clear that
But you can't testify right now, right? You can't make an argument about the video. So your opinion about it right now, that's not appropriate.
I want to.
Keep going. For the record, the objection was sustained.
You made a reference to being a reference to chesting up with the driver of the vehicle. What was said at that point between you and who you were chesting up with?
Well, I'm not going to go back to that. But, I was sitting there saying that you shouldn't be hitting a woman. No, Brooks should not be hitting a woman. And Brooks was saying that Erica Patterson is not a woman.
Are you sure that's what you heard? At that moment, when you were chesting up, in your words?
Yes?
You sure that's what you heard?
Yes.
What then happened from that point?
Then we started brawling it out. Oh, me and Brooks started brawling it out.
What do you mean by brawling it out?
Threw a couple punches. I threw a punch. Brooks smacked me.
So did you put that in the report that you made, or the summary of the report that you gave to, I think it was Attorney Whitchaw said, a detective?
Objection, there's no evidence. This witness prepared a report or a summary.
Sustained.
Did you report that in your report?
It's something that's in my memory, but I hope I did.
Would it be fair to say that if you had just brawled with someone and talked to a detective that you would report it? Would that be fair to say?
Can you say that again?
Would it be fair to say that if you had just had a brawl with someone and you talked to police directly after the brawl that you would report it? Would that be fair to say?
Okay. I know you're asking a question, but
Hold on, you need to ask. You do need to ask.
okay.
You do need to answer his question. It called for a yes or no answer.
Okay, it's not in the report. I specifically said.
Hold on, that's not a question though.
I'm
Okay,
sorry.
so that's okay. Ask your next question.
Would it be fair to say by the video footage that there was no brawl or punches thrown by either party? Would that be fair to say?
There was.
Can we show the witness the video again?
Are you asking her whether the video shows a brawl?
Would it be fair to say that the video shows a brawl in which you just said that punches were thrown? That'd be fair to say.
Okay, so what's a brawl to you?
You can't.
Oh, I'm sorry.
I know.
Okay,
I think
well,
hold on, Mr. Brooks, are you trying to ask whether are you going to confirm with her that she saw the video, and then on that video, you cannot see a brawl between her and Mr. Brooks? Is that what you're trying to get at?
A version of that, yes, but I was
You
gonna
got to ask the questions
I
though
was
to
gonna
get to
say,
that.
can the video be shown to her again?
Ask your questions, sir.
In the video that you saw, would it be fair to say that a brawl was not depicted on that video? Would that be fair to say?
I don't know big words. What's depicted?
Can you see it in the video? Is that what you mean?
Yes.
That's what I mean.
Yes, I could see it.
You could see the brawl?
Yeah, I say it's a brawl. It's just like a push, looks like a push, but it was a smack. And I got up and yeah.
You got up, so you were
I got up and swung.
You were knocked to the ground?
No.
So where did you get up from?
From being pushed and smacked.
So you fell to the ground?
I didn't fall to the ground.
Sustained. Next question, sir.
So would it be fair to say that in the video it shows you being knocked to the ground?
I was not knocked to the ground. I staggered back.
Would it be Hold off for a second.
You and me both.
I,
People need to make sure their phones and other electronics are not inaudible.
would it be fair to say that the video does not show you being knocked to the ground at any point? Would that be a fair assessment?
So I'll object to relevance because the witness never testified that she was knocked to the ground. So this is not a question aimed at her credibility.
She just said she got knocked to the ground.
She did not.
She,
She said she got up. I'm sorry. She said she got up, which would constitute being, if you're not knocked to the ground or down,
war
you can't
words
get up.
here, Mr. Brooks.
I'm sorry.
It's okay. No, she was clear. I think she clarified what it meant by getting up, and it might mean something different to you than it does to her. But we need to keep going.
So can I ask what is getting up? What does getting up mean to you?
Stagger back.
So it would be fair to ask you then, does the video show you staggering back?
It does.
Does it show you being, as you called it, smacked?
It does.
Can we show her the video again?
Go ahead. Play the video. You want it to the jury or to her?
To her.
All
I
right.
would ask that we publish it.
I think it's an exhibit, sir, and let's publish it. Okay.
Your Honor, would it be too much to ask if we went straight to that part of the video?
I don't know what part it is. I don't have the timestamp.
I'm guessing this might be it right here.
It's coming up.
Let's just watch, and then we'll ask questions. You'll ask questions when we're done watching.
So we're playing from 3 minutes and 9 seconds on Exhibit 3.
You can stop. That's
All right. What's the time for the stopping of the video, please?
3 minutes and 47 seconds.
All right. Your question for her then, based on that?
My question would be, you just viewed the video again. That'd be fair to say.
I did.
At any time in that video, were you in fact smacked and staggered back?
Can I tell the exact time?
If you know, yes, go ahead.
At 3:23.
Can we see 323?
Go ahead. We'll start it a little bit before, so make sure to capture it. You should be able to see the time.
24.
Okay.
So we went from about 319 to 327.
Thank you. Your question regarding the video, sir?
My question again would be the same question. You just saw it again. In the portion of the video you just saw, would it be fair to say, on your part, your interpretation, that you were in fact smacked and staggered back?
Yes.
Next question.
Were you, are you sure you weren't over exaggerating that?
No.
It looked like a push.
Objection argumentative.
Sustained.
Would you say again what happened directly after that?
Directly after the smack,
Directly after what you say is a smack.
staggered back.
No, directly after that whole incident.
I call it get up, but I came back and swung.
Would it be fair to say that the video doesn't show any of that you just said? Would that be fair?
It shows it somewhere.
So would it be fair that you're saying your interpretation of what you just saw would constitute a brawl, as you say, or brawling it out, as you say?
Hold on, Mr. Brooks. I've given you a lot of leeway on this topic. What's the relevance of all of this at this point? I think you made your point about what happened and what didn't, and what's in the video and what's not, and the jury can ultimately decide that. You can argue it later on to the jury.
I'm sorry, I thought this state
Where are we going?
supposed to object to that. If they saw an objection, I'm a little confused about that.
I need the questioning to kind of circle back to what's relevant for the trial.
Well, I thought it was relevant because of what the video is actually depicting.
And that video is going to speak for itself. It's been an exhibit.
Yes, it does.
And so you've asked a lot of questions about it. So let's move on. Under 906.11, that's my authority. I'm telling you to move forward. Next line of
Did
questioning.
you hear anything after the, as you say, brawling out? Did you hear anything coming from the vehicle? Was anything said to you directly coming from the vehicle at that point?
Do you understand the question?
Would it be after you leave? Oh wait, Brooks leaves? Or when
I was
Brooks gets
clearing
in?
what I just asked after the brawling it out.
But you asked directed at her, and then you said anything from the vehicle. So that's a compound question. So you need to be specific.
Did you hear anything after the brawling it out, as you say? Did you hear anything directed towards you?
Directed towards me? No.
Did you hear anything directed towards Nick?
I remember something being said.
Do you recall what was said?
I do not.
Did you hear anything directed towards Erica?
Yes.
What did you hear directed towards Erica?
At what time?
Right after the brawling it out, as you say. Did you hear anything directed specifically towards Erica?
Not till he left. No, not till Brooks left.
Would you say that again?
Not till Brooks left.
So, did you or did you not hear anything directed towards Erica after the brawling it out, as you say?
Oh, okay, no.
So, can we pull that statement up again?
Go ahead. The state would do that once again. Just to the preview.
I'm reading directly from this statement where it says,
Mr. Brooks, it may or may not be a statement, so you need to be accurate. I know you're referring to the police report.
The summary of the statement. I'm reading directly from the summary of the statement where it says, Runkle stated that after a short dispute between her, Kirby, and Brooks, she saw Brooks get back into the red SUV and heard him saying something to the effect of, F you effing bees, you're dead, as he was leaving.
So I'll object on two grounds. One, asked and answered, and two, this could confuse the witness because it's not, she used the F and the B.
Sustained.
It was something on the back end of that I didn't get to.
I'm not sure what you mean by that, sir, but you've
It was-
already asked that question before, so the objection is sustained.
I actually don't recall asking a question directly to that part of the summary.
I do. You read through that previously.
Do you remember what the question was so that I don't re-ask the same question?
Mr. Brooks, move on.
Did you ever hear something to the effect of F you effing B's, you're dead?
I did.
At what point did you hear that?
While Brooks was leaving.
So that would it be fair to say that you heard that after the brawling
Yes.
it out?
You shook your head. Can you say
Yes.
it? Thank you.
That's a little confusing. So
Mr. Brooks, that's not a question. You're attempting to
I'm
testify.
about to ask a question.
You
If I
can't
can
do
get
that.
to it,
Ask your question. But you also can't mischaracterize the testimony or the evidence up to this point.
what do you mean?
In your questions, you can't mischaracterize prior testimony or evidence. You have to be accurate. So
I'm trying to be, but it's
what's your next question, sir?
kind of hard. Just a quick second.
Right, unless you have a different topic.
It
Hold on.
is.
Anything related to this, what's in the summary, the questions regarding what she heard or didn't hear around this time, we've gone through that. You've gone through it. Under 906.11, you need to move on and ask a new line of questions.
I was trying to, if I can get to it.
Go ahead.
This part of the summary that I'm looking at now says Runkle stated that she did see pictures of Brooks following the Christmas parade incident via social media, and Runkle confirmed that was Brooks was I don't know, it looks kind of, I don't know if that's a mark on my screen that's going through, okay. I couldn't read it.
I'll object. I don't think there was a question there.
Right.
I didn't get to it yet.
Well, then I'll object to the ongoing commentary with lack of any questioning.
And I'll sustain that objection.
Oh, I do have a question. You said that you had known Erica roughly since you were rooming up at the women's shelter. Would that be fair to say?
Yes.
Do you have any idea why she would refer to you as Corey Gray?
Because I go by that.
So how close would you say you guys were?
Close.
Close, like hung out all the time, every day?
Yes. Hung out every day. Sorry.
And do you know of any time before November the 21st of 2021? Do you know of any time before that Erica mentioned to you anything about the relationship that she had with Brooks outside of what you learned that day?
Can you say that again?
At any time before November 21st of 2021, did Erica ever confide any information to you before that day?
She did.
What was the nature of the information?
It's not allowed to be brought up.
I think she's referring to a pretrial ruling that she's aware of.
Yep.
So, you want to rethink asking that question, sir? Otherwise, I'm going to allow her to answer it.
What pretrial?
I'm not going to state.
No,
That
I'm not.
right now.
Are we both privy to the same pretrial procedure?
There was a pretrial ruling about.
Do you want her to answer that question, or do you want to move on?
I want to move on.
All right, I'll strike that question from the record. The jury will disregard the question that was asked.
So I would want to ask, was there any, during the brawling out point, was there any interaction between the driver of the vehicle and Nick?
There was.
Do you remember what the nature of that interaction or exchange was between those two?
I don't know. I just remember jumping in front.
Do you recall any threats being made towards Nick or from Nick towards the driver of the vehicle?
Oh, I do.
Relevance.
Overruled. She may answer.
I do.
Do you remember what was said specifically?
Not specifically, but I remember Brooks getting mad because Nick was coming to Erica's rescue. Right along with Corey. Me.
Do you recall any knife being involved in any of that situation
No
during
knife.
that exchange whatsoever?
No knife.
Were you aware that that was why police was responding to that incident?
I did not.
Did you at any time have a knife during that incident?
I did not.
Do you know if Nick had a knife during that incident?
He did not.
Do you know if Erica had a knife Do you know if Erica had a knife during that incident?
She did not.
As far as your memory, do you recall reporting that a knife was involved in that incident?
I do not.
Do you recall if Nick reported a knife being involved in that incident?
It's possible.
Do you recall Erica reporting that a knife was involved in that incident?
I do not.
You testified to drinking a half pint of vodka that day. Was that the only thing you had to drink that day?
Yes.
Would it be fair to say that you were tipsy?
Yes.
Would it be fair to say that you may even have been intoxicated?
No.
For any reason that day, acknowledging that you were drinking, would that have impaired your thinking of the situation in any way?
No.
So would it be fair to say that you were of clear and sober mind during that whole incident after drinking a half pint of vodka?
Yes.
So there, to the best of your memory, there wouldn't be any reason why you may have left something out or maybe not been clear about anything that happened during that specific incident.
Possibly left some things out.
Do you remember what they might have been?
No.
Do you know the plaintiff?
Objection. For previous reasons.
Sustained.
Have you ever seen the plaintiff?
Objection.
Sustained.
Have you ever had any interaction with the plaintiff?
Objection.
Sustained.
No further questions, Your Honor.
Thank you. Any redirect?
Very, very briefly, Your Honor.
Go ahead.
Ms. Runkle, you met with Detective David Van Els to provide a statement on November 22nd of 2021. Do you remember that?
Yes.
That's accurate?
Yes.
Okay. Do you remember telling Detective Van Els, when he was asking you about this incident, that when you arrived you heard Daryl Brooks telling Erica Patterson that he was going to, quote, smash her face in and that he was going to kill her, end quote?
Yes.
Okay. Do you remember telling Detective Van Els that as you saw Brooks get back into the red SUV, you heard him say something to the effect of, quote, fuck you, fucking bitches, you're dead, end quote?
I do.
Okay. During your cross-examination, you repeatedly referred to a person as Brooks. The person depicted in the video, Exhibit 3, the person that you chested up to, is that person in the courtroom?
He is.
Can you point him out for us and just very clearly tell us where he's sitting, what he's wearing?
You want me to point?
Yes, please.
All right, he's right there and he's wearing orange.
I'd ask the record to reflect that the witness has identified the defendant.
It will.
And I have no further questions. Thank you.
Thank you. Thank you, ma'am. You may step down. Thank you. All rise for the jurors. The other thing is I had not been utilizing an all rise. Sometimes you stand, sometimes you don't. It is something I'd like to go back to, especially as it relates to the jurors. It's out of respect for them. So I will be doing an all rise for when the jurors enter and exit. And just given some of our logistics, I am not looking for an all rise for when I enter at all. So